All right, good evening. Welcome to the webinar. This evening's webinar is on avoiding claims against wills. So, a little bit of a controversial topic. What I'm going to do though is share some slides with you and we'll get into the content of the webinar. All right. So, avoiding claims against wills. Now, I'm coming at this topic from the perspective of prevention. I'm coming at it from an estate planning perspective for the person preparing their own will to avoid claims in the future should they pass away. I am against, I suppose, morally, those people who whose law firms prosper from poor estate planning because they bank on having a certain amount of claims that they act on. I think that if you explain things properly to people so their wishes are actually followed through, or they at least are more aware of the risks in a claim and proceed with that understanding, that will certainly, I can live with myself better having done my job. And look, the fact is that once someone passes away, if this planning hasn't been done properly, it's often too late after they've passed away to try to prevent a claim. All you're then dealing with is the executors are trying to minimise claims if the estate planning hasn't been done right in the first place. So I should introduce myself a little bit better. My name is Jacqui Brauman. I am the Principal Solicitor at TBA Law. We operate primarily in Central Victoria, but throughout Victoria really. I've got offices in Nagambie, Wallan, Seymour, Romsey and Melbourne. I'm just going to close my mail so I don't keep getting those notifications. I'm also an accredited specialist through the Law Institute of Victoria. Out of about, I think there's about 12,000 practicing lawyers in Victoria. There's only about 80 of us that have this accreditation. To get the accreditation, we go through a 12-month examination process. And prior to even applying for the accreditation, I did my master's degree as well, majoring in this area. So that's me. And whilst I'm a lawyer, it's not all that I am. I've also got a photo there of my husband and my dog on our boat, and that image is at Eildon actually. So that's what I enjoy in my spare time, fishing. Now, on to the important content. So, estate planning, this little wheel here shows all the aspects of estate planning. So, estate planning is not just a will anymore these days. It's so much more complex. 50 years ago, people's lives were much simpler. What they owned were much simpler. The laws and regulations were much simpler. Unfortunately, it's not the case anymore. And so, as I was saying at the very beginning, the estate planning aspect of trying to avoid claims is the most crucial point. How you own your property, what evidence and information you leave, who you have appointed into important roles in your will and as powers of attorney are very important. How you manage your superannuation, whether you use family discretionary trusts as an estate planning tool, or whether you use testamentary trusts in your will, whether you have life insurance policies or other interesting sorts of investments that can help in the estate planning process. So all of these things are things that strategically a solicitor helping with estate planning should be thinking about. It's not necessarily something that the solicitor should run you through over everything, because some of it may not be relevant for your circumstance, but certainly in their mind, that is what is being processed and thought about. So all of these aspects are covered. Okay, so the laws around this area changed in 2015. Victoria used to have the most loose, I suppose, laws in this area until it was tightened up in 2015. So in Australia, in every state, we have complete testamentary freedom. That means we can do whatever we like in our will. So in that way, we are lucky, because in many countries, or in fact probably most countries, a majority of countries rather, around the world, people do not have testamentary freedom. Often the law specifies how assets are passed on to the next generation. If not all the assets, at least a percentage. So because we have testamentary freedom, the law has also developed over hundreds of years that you still have a moral obligation to certain people in your lives to look after them. And so that is the only caveat, I suppose, on testamentary freedom in Australia. Now, having said that, before 2015 in Victoria, just about anyone could make a claim against a will. So anyone, as in a carer coming in to help someone once a week, the neighbour who went and got the shopping for someone. It was really quite open slather. Nieces and nephews, great grandchildren. So the unfairness of it, I suppose, was assessed through the Law Reform Commission, and some new legislation was recommended. 2015, it was put through Victorian Parliament, and it's narrowed down who can make a claim into actual categories of people. Now, broadly speaking, those categories are spouses, children, and people who are financially dependent. So spouses include de facto spouses and people who have a registered caring relationship. Children include minor children and adult children. Minor children have better claims than adult children. It includes stepchildren. And then financially dependent people. So that includes someone who is living in the house, whether they're related or not, who has some level of interdependence, financially or otherwise. So once someone can establish that they have a claim, it's then a question of how much they can claim. And each of those categories have different bearings, I suppose. Not all the categories are worth the same, so to speak. So a child would have a far better claim than a adult niece who was unemployed living in the house or something like that. And then in assessing the amount or quantum of a claim, the court takes into account all sorts of factors. The nature of the relationship, evidence that the deceased left behind about the nature of the relationship and why they left someone out. All of this stuff is really relevant. Also the size and nature of the estate, the financial position of the beneficiaries and the person making the claim. So all of this is assessed. And this is where the fairness aspect comes in. So the quantum, the calculation of what the claim should be, is where fairness is assessed. So bearing that in mind, quite often I have clients come to me who have one or two children potentially who are estranged, sometimes 20 or 30 years, they haven't spoken with them, or sometimes it has been a more recent estrangement due to long-term violence or drug abuse, and there's finally been a rift where the parent has said that is enough. So those people come to me and they want to leave a child out. So what sort of advice do I give them? Now, it will depend very much on what is in their estate. But the advice that I give them is there are ways to minimize the chance of someone making a claim. So the first strategy that we use is to minimize the estate assets, because if there is very little left in the estate, then potentially we could still leave the children in the will, because they will get an equal share of nothing because the estate has been minimized. So that is one strategy that I use quite regularly. Now, the way we do that is there's two broad categories of assets. There are estate assets and there are non-estate assets. So estate assets are in your estate and go accordance with your will. Non-estate assets obviously don't go in accordance with your will, right? So the more assets we can move from estate assets to non-estate assets, the less that is in the estate. So certain types of non-estate assets include superannuation, life insurance, some life insurances, some certain types of investments, family trusts, and jointly held assets. All right. So there are those 5 main classes of non-estate assets. So I look at someone's estate and we start thinking, okay, how can we move as much of these assets as possible across to non-estate assets? So recently I had a elderly lady come to see me who was doing this very thing. Unfortunately, she had just escaped one of her children from a situation where there was some pretty serious elder abuse. She had already liquidated her estate, so all she had was money in the bank, and it was, about $400,000 or $500,000. So a fairly sort of average sized estate when you think about it, because she'd sold the house and she had a little bit of savings and that was it. So my advice to her was, if we cut the kids out of the will, they're going to make a claim and they're going to get something. Instead, why don't we move your money into an account that we create, which is a joint account with someone that you trust, and then you only leave a minimal amount for your actual living arrangements in your own account. So the strategy was that we moved $300,000 across into a joint account and left her about 100,000 in her ordinary operating account. So her estate is only going to end up with 100,000 in it. So her 3 children are going to get a third each of that, which is only about $30,000 after expenses. And she could live with that because the 300,000 that she'd moved into a joint account was guaranteed to go to the person that she wanted it to go to. So that was the first strategy. That was just a bank account. So that was fairly easy to do. I'm working with another lady at the moment who's struggling to come to terms with the fact that she potentially someone could make a claim against her will, because she thought that this is what she wants to do and that will happen. And then I said, well, actually, if you leave out these 3 children and leave it all to your 4th, those 3 children are likely to make a claim. So this other woman, still had her house. So she hadn't liquidated everything yet. So again, I've used the same strategy with her and said, look, if you really want to minimize your assets in your will and make sure the house is not part of the estate, then put your child onto the house title with you as joint proprietors, and it will automatically go to that child once you pass away. Now, there's obviously stamp duty consequences, which were going to cost about $7,000 to do that. So she's at the moment assessing whether spending $7,000 now to guarantee that, $200,000 or $300,000 doesn't get lost to children that she doesn't want to have. So it's a difficult decision to be made, but that's the guaranteed way of ensuring that someone who makes a claim against your will is going to get very little, or they see that the estate is worth nothing and they don't bother. The other kind of assets that there are is a life insurance policy. So, and this works well with superannuation as well. So for blended family situations where you've got a second marriage between a husband and wife, but there are children from the first marriage, quite often, to appease the children from the first marriage, a life insurance policy will have the children as the beneficiaries, or the superannuation will have the children as the beneficiaries. So they get a major payout on the death of their parent, which usually stops them from making a claim on the will when that parent leaves their entire estate to their spouse, because it's a second marriage. And that's a fair way of doing it. Again, it depends on the circumstances in the family and what sort of assets there are. But it gives some flexibility, I suppose, in the planning. And the other type of non-estate asset, there are certain types of investment products that you can get through financial planners. Insurance bonds are one of those types. So instead of putting money into a term deposit, someone could put money into an insurance bond instead. So quite often they'll have a similar rate of return, an interest rate, and they will get income from the bond for life. But the interesting thing about the insurance bond is that the beneficiaries can actually be named on that insurance bond, so that the investment that was made, like the term deposit, the money that's sitting in the bond will not come back into the estate of the deceased person. It will go directly to the beneficiaries that have been named. So those are some strategies that we use in estate planning to minimise an estate, because if there's very little in an estate, a claim against nothing is nothing. So that's one strategy. The other strategy that we have is to set it all out as plainly as possible. And quite often we use these two strategies together. We'll minimize the estate to a certain degree, but sometimes there are assets that we can't create or turn into non-estate assets, or it's too expensive to do it. Like the woman I was talking about who's contemplating paying the $7,000 on stamp duty. You know, the $7,000 is relatively small compared to some tax that has to be paid to do similar things. So the other thing that I advise people on is if they're insistent on leaving someone out of the will, we must put in a clause in the will to say that that person is specifically being omitted from anything and the reasons why. The reasons on the face of the will don't have to be detailed. The will can then refer to a letter, and that letter only has to be made public in the proceedings if there is a claim. It doesn't have to be brought to light if there is no claim. And so often I'll get someone to do a couple of pages of evidence. Now, the reason that we go down this path is, like I was talking about before, in an assessment for quantum, if the person already meets a category of someone who can make a claim, the next question is how much can they get from their claim? We want to minimize that amount, right? So the way we do that is by putting as much evidence from the deceased person as possible. Unfortunately, the reason why so many claims are successful is because it is the claimant's word against the family, right? And the family don't have enough evidence. So the claimant can say whatever they like, and there's no real comeback against it because the family doesn't have enough intimate detail. So if the deceased person themselves, before they have died, has left quite a few pages about why the estrangement happened, what the relationship is really like, how much money the person has stolen off them during their lifetime, all these sorts of things, it's so helpful for the family, for the executors who have to run a claim later to try and knock something on the head as early as possible and minimize a claim or even knock it out. So that's the second strategy. So a combination of those two strategies are usually where we're going with estate planning to try and avoid a claim against a will. The other thing that people often ask me when they come in to see me is that they have sometimes seen some American TV or they've had some advice from their friends and they say, can I leave the person $1 and that knocks out their claim? No, it's not valid here in Victoria or in fact any state in Australia. Again, that might only be valid in some states in the US if it's been some US TV that someone's been watching. Leaving someone a minimal amount does not stop them from making a claim. The other thing people sometimes say is, let's leave them a little bit more than a minimal amount. Say, let's leave them $20,000. And then the clause will say, but if they make a claim, they get nothing. So again, not a legally valid clause. It will not work. So that's why we look at these other two strategies that I've just spoken through in detail. Minimizing the estate assets and then leaving as much evidence as possible to help the executors if there is a claim. So I've been rambling on nearly half an hour now. I'll quickly whip through the last couple of slides, and then if anyone has any questions, please either use the chat box or the question and answer box, and I'll have a look there at the end and answer those for anyone who has anything that's specifically burning about a situation that they're in. So this is sort of the process that I take people through in doing their estate planning. So they start at the bottom of the pyramid and quite often they're feeling overwhelmed, very uncertain. They're worried about leaving someone out of the will. They don't understand the legal situation. They're quite often feeling fairly exhausted from the overwhelm of just uncertainty and worrying and not getting correct information, and just it all getting a little bit hard. And then once they start doing a little bit of research, and that's why I do these webinars and Facebook Lives and have articles and things like that, they can start thinking, okay, so actually maybe I need a little bit of advice, I need to speak to someone. Then they start feeling like they're getting a bit proactive. They get started once they come in to see me. They now get the information that I've just been talking about with you tonight, and they can see a plan forward. And quite often they've had to make some kind of compromise in what they were actually thinking they wanted to happen, but at least they've come away with certainty and feeling a lot more in control and protected. Our estate planning process involves 2 appointments. So once someone's ready to go, they ring our office, make an appointment, they get some initial information emailed to them. They have their first appointment with me, which is basically an information collecting appointment, and then I give them all this sort of advice if it's relevant, but it's obviously much more specific. Then we make a second appointment. In between those 2 appointments, I send them drafts, and if there's any information that's missing, I get them to email that back to me. Second appointment is where we sign everything and everything is complete and valid. Quite often, though, we're also doing powers of attorney, and we need attorneys to sign acceptance pages, so we do some running around after that. We also do binding nominations on super funds and send those into super funds, and then we deliver all the certified documents to the client once all of that's finished. So this process takes about 2 or 3 weeks, and someone can have certainty and the process is done. It's off their plate. They don't have to worry about it. They know where they stand. So we have various packages for our estate planning, and what I like to offer people who do their research first and come along to webinars like this is to say, well, look, if you don't know if you need the whole process done, at least come and have an initial appointment with me where I will go through your whole family situation and do a review and give specific advice like this. If you don't go ahead, you don't have to pay the full package. The cost will only be $450 for the review and the advice. So that is pretty much what I wanted to talk about tonight. I wanted to thank you for coming along to the webinar. Hopefully it's answered some of the questions that you wanted answered. Like I said at the beginning, this was about estate planning and preventing a claim against a will before someone passes away, which is pretty much the only time to do it, because after someone's passed away, if the evidence hasn't been left, it's really about trying to negotiate to minimise a claim. So I am now going to stop the share of the screen and come back and have a look for questions. So Q&A, no open questions in there. And the chat box, no, we are all looking pretty good. All right, I hope that wasn't too much information too quickly. I will send a replay video through so you can, then you can fast forward and rewind and just look at those bits of information that you really wanted to pick up on again. Quite often when we review something, we pick up more things a second time or a third time. So I'm going to stop the recording now, and if you need to get in contact with me, my email and everything is on our website, tbalaw.com.au. You can email me directly there. The phone number's there as well if you want to book an appointment. And other ways to contact us are direct messages through Facebook. We're regularly checking Facebook there as well for anyone who asks questions there. So thank you very much. Good evening. And I hope that was really useful.